Start the recording now. Good. Okay, let me just share screen. Okay, hold on. Okay, there we go. Okay, so before we begin the actual discussion on the topic for week 2, is there anything that anyone would like to raise? Any questions? Perhaps about the discussion we had last week? Anything you wanted to clarify?
I had a question today when I was reading through some stuff.
Yes, hold on. Yes, Josh, go ahead.
I was unsure on the difference between a civil law country as opposed to a common law country, because as far as I understood it, common law embraced the idea of civil law, and so I wasn't clear on the distinction.
Okay, so you would like to know the difference between civil law and common law systems? Is that the question?
Yeah, basically.
Okay, yeah. So common law systems, of course, is something that's quite familiar to most of you. And when you speak of common law systems, these would be the systems that are found in countries that are associated with the UK. So you have that of the UK, you have India, you have Australia, you have New Zealand, and you even have Pakistan. Civil law systems, these would normally, to an extent, there's also the US, which might have a common law system, and I'm going to go down to explaining it in a short while. I'm just, providing the context. Civil law systems should be represented by countries such as the Philippines, much of continental Europe. So you have the Netherlands, you have Belgium, you have Germany, and so on. Now, what is the difference? Let's begin by talking about civil law systems. In civil law systems, when you talk about laws, these laws are typically codified. So these laws are usually found in statute books. So if you want to know anything about what the law is on contracts, or how certain contracts might be interpreted, or what the crimes might be, or if you want to know anything about evidence and so on, you go to statute books. So these laws are therefore codified. They have been passed by Parliament. And the only role of the judiciary in that instance is to interpret the law as found in the codified laws, or laws that have been passed by the legislatures. So in that case, the function of the judiciary is mainly interpretive. If you talk of a common law system, although you might find laws such as the Crimes Act, typically in a common law system, you might see that laws are actually judge-made, in the sense that even in the absence of legislation, that will not stop or prevent the judiciary from interpreting the law. So where the law is absent, the judges actually end up creating the law. This is why it's called judge-made law. And it is in common law systems as well. It is not necessary that laws on a subject are actually codified. So you'll actually see laws, in bits and pieces. So the main distinction, therefore, is that in civil law systems, the laws are typically codified and passed by the legislature. If the law is silent on a point, there is nothing that the judiciary can do. Because the function of the judiciary is strongly interpretive. The judges interpret what the law is. It typically cannot create the law.
Excuse me, man, Joe.
Yes, go ahead. Who's this?
Yeah, it's Andrew.
Andrew. Yes, go ahead, Andrew.
It just might be helpful if everyone else can mute their microphones while you're talking. There's a lot of other noise coming through.
Oh, that's right.
A bit of it's coming from Mojo Rising.
Yeah. So, thank you, Andrew. So can I request the others, if you're not talking, if you don't want to speak, just unmute the mic. So, because otherwise there's just so much echoes and sounds going on. So I think that was clear. So going back to the idea of the common law system, it is judge-made law in the sense that even in the absence of legislation on a subject, the judges will so assuming that there is an actual controversy and the law is silent. The law is silent because the legislature has not passed any law on that subject. The judges will actually create the law. So more than interpreting the law because it doesn't exist, the judges end up creating the law. So are we clear on that? Now, what then happens is that, assuming that there is judge-made law, what then is the effect in relation to Parliament? Because Parliament actually is the one that creates law. So when Parliament actually passes a law and that law touches upon something that has already been created in the form, so decisions of judges end up becoming law, whether it's in civil law systems or common law systems. As we know, any decision actually becomes part of the law. But crucially in common law systems, the decisions made by judges, assuming that it is on an area that is not the subject of legislation by Parliament, that becomes a law of its own. But Parliament actually is in a position to actually modify or abrogate that which has been decided by judges. So even if there is judge-made law on a subject, it is open to Parliament to actually change or abrogate a decision made by judges. On the other hand, judges cannot change a law that has been passed by Parliament. Is that clear? Judges cannot abrogate a law that has been passed by Parliament. All that judges can do, for example, might be to declare certain laws passed by Parliament to be unconstitutional. Okay, so was that distinction clear enough? Clear? Good, okay.
Yeah.
Any other questions that you might have? And now, let me just continue on that point. It'll be very surprising because if you are, so I'm a civil law lawyer actually, and I'm also a common law lawyer because I'm a solicitor and barrister in New Zealand. If you are a civil law lawyer, it is a very foreign experience to you when all of a sudden you don't have a set of codified books to just go like, where's the civil code or where's the criminal code? Because then what happens is that in a common law system, what you then do is not to go to the statute books. What you do is to go to judicial decisions. So let me repeat that. If you are a civil law lawyer and you want to know what the law is, the first point of visit, the first place you go to would be the statute books. You look at the codes. On the other hand, if you are a common law lawyer, you don't go to the codes because they normally don't exist. Instead, you go to decisions of judges. That becomes more complex because for two reasons. There could be various decisions made by judges, and in that case, there is even a strong possibility that a legal principle on a subject, let's assuming in Australia, it's possible that the legal principle may actually arise from a decision by an Indian Supreme Court, or it could be a decision of the UK, or it could even be a decision of a New Zealand court. These decisions have persuasive effect. They are not conclusive upon courts of Australia, but they do have a persuasive effect. So typically, when the law as passed by Parliament is silent on a subject, what can happen and what typically lawyers would tend to do would then be to do research to find out what exactly is the law on this subject across other jurisdictions. Meaning when I say jurisdictions, in other countries. That's what a lawyer would do. And then the lawyer would then present to the judge, this is what prior decisions are, following stare decisis, for example. In civil law systems, it's quite simple. All they do is that they go to the decisions made by higher courts in that specific jurisdiction. Now let's see from Vivian, but if they wish for the law to be applied, then okay, that seems to be incomplete. What was the question there? I may have missed the conversation.
Sorry, Manyo, it's Paul.
Banjo. Yes, Paul.
Box. If the judiciary cannot overturn a law, but they can deem a law unconstitutional, is there an obligation on Parliament, in this instance, they must correct it? I mean, it seems that the judiciary can declare it unconstitutional, but I can't find anything that says they then have to correct it in the Houses.
we have a situation where you say that the law has been declared unconstitutional by the courts. Is that it?
Yes.
And then what's the question there? What then does...
So is there an obligation upon the Houses of Parliament to then correct that law or overturn it themselves? Because if the judiciary cannot do it, surely that law sits in limbo until something's done to it.
Yes, that's just the way it is. Parliament may decide not to do anything about it and leave it to the judges to formulate the legal principles on that subject.
So if they deem it unconstitutional, it can still stand, and every time that law is applied, it'll go before the courts.
No. If a law is unconstitutional, it means it has no legal effect.
Manjo.
It is not. Hold on. One at a time, please. Let me repeat. If a law is declared by the courts to be unconstitutional, it has no legal effect. Okay? But Parliament has no obligation to then do something about the law, either to modify it or to come up with a new law. So what then happens is, in the absence of that specific law that has been declared unconstitutional, it is left to the judiciary to pick up the pieces and to determine what the legal principles might be that might apply to a specific actual controversy. Now, we make a distinction.
Manju.
Hold on. Who's that? Martin? I'll go back to you, Martin, in a short while.
It's Martin. Yeah.
Who was it?
I think there's some confusion because people thought when you were explaining the difference between a civil system and a common law system, people thought you were referring, the people who came in later thought you were referring to Australia. I think that's the basis of the confusion.
Oh, okay. Now, I don't know where to begin. Okay. So let me go back. So there was a question raised earlier. Was it by Paul? So the question of Paul was, assuming yeah, that's right. So we should be talking of a common law system then. I think the question of Paul was, in a common law system, assuming that the law that was passed by Parliament has been declared unconstitutional, the first question was, does Parliament have an obligation in the common law system to actually pass another legislation to address the law that was declared unconstitutional? The answer is no. Now the question is, what is the legal effect if Parliament does nothing about a law that has been declared unconstitutional? So let's begin by answering, and we're talking of a common law system here. Let's begin by saying that if a law has been declared unconstitutional, that law has no legal effect. Now, in the absence of that law, because that law has no legal effect, what that means is that it is possible that there is no law on that subject. And because there is no law on that specific field, it is now up to the judiciary to pick up the pieces and determine what the legal principles should be that should apply, even in the absence of a law passed by Parliament. So in that context, as we say, in the common law systems, the absence of specific legislation will not prevent judges from adjudicating on an actual controversy. So in the absence, we're talking of common law systems here, it was quite clear. So in a common law system, in the absence of legislation, the judiciary will step in to state what the law should be. Okay, now, I would like to make a distinction between a law being unconstitutional and therefore having no legal effect and having an operative effect. Okay, so I'm trying to make a distinction here. It is possible for a law to be declared unconstitutional and therefore of no legal effect, meaning it has no force of law. However, it may have an operative effect in the sense that if there had been certain rights and duties and certain liabilities that may have been formed as a result of a previous law that was then declared unconstitutional, it is possible that to an extent there would have been that law that had been declared unconstitutional can have an operative effect on certain rights and duties, and they would still have, and those rights and duties that would have been affected would still be recognized. Are we clear about that? Now, would you like me to answer that question in relation to the civil law system, or do we leave it at that? Was that clear enough?
Yeah, no, that answers my question. Okay. Thank you, Manju.
Yes. Now, what was the other question? So I'm having a problem sometimes trying to trace the chat box because as I speak, chats are going on. Was there anything important that you think, you should be asking now? because there's so many things going on in the chat box. I'm missing some of them. None? When I get the chance, I'm gonna have a look at the chat box, but if I missed it, I apologize, because the problem with men, and I'm probably stereotyping, is that we're just one-track people. We can't be doing two things at one time. So when I'm talking, that's all I'm doing. And I can't be reading the chat box at the same time. Now, if there was something crucial and I think you wanted to raise it, please do so. Or otherwise, I'll move on to the topic for tonight. We're all good? Okay, so let's proceed. So for tonight, we're going to be talking about, the topic is on the idea of responsible government in a parliamentary system. As of this time, you will notice that a lot of the things that we raise are actually kind of based on legal principles. I'm not yet formulating any case problems. And the reason is, it's very important for you to have a good grounding on legal principles, because the legal principles are going to be very important. Okay, so that's why we're just having an understanding now of basic legal constitutional law principles. So for tonight, at the end of the session, you should then be able to discuss and explain the concept of responsible government and provide an overview of Commonwealth executive powers. So let's begin with the first one. What do you think are the implications of the idea of representative government on the power of judicial review? You've probably had the chance to think about this question. I'd like to give you 2 minutes to please give your answer in the chat box. So for those who don't want to use the mic at some point, for the purpose of having the points for online participation, you need to write something in the chat box. You need to get involved at least through the chat box. So I'm asking everyone, if possible, to please type your answers in the next 2 minutes. Give me your answer in relation to that question. What do you think are the implications of the idea of representative government on the power of judicial review? We'll give it 2 minutes, and then we can start discussing that. I won't actually have the chance to go through your answers right now, but hopefully I will at some point. But I'm going to check the names of everyone who contributed something here. I'm just trying to read some of the answers here while I have the chance. Well, the problem is when a new message comes in, what I was reading moves up and disappears. Hold on. So that's a problem with the chat box, because while I'm reading something and something pops in, it disappears. Okay, that should be sufficient. We'll give it a few more seconds so that we can proceed. It's interesting from Lori here. Government can't interfere with the judiciary. It has to remain separate. Okay. Yep. Can't interfere with the judiciary. That's an interesting point. Okay, let me just say something there on that point. That's crucial, because for those of you who live in Queensland, you'll probably recall the crisis concerning the Supreme Court Chief Justice, Carmody, where a lot of people, especially in the legal profession, were saying that there was a lot of politicking going on, and that the Parliament, the Queensland Parliament, was actually getting involved in the judiciary. In other words, the choice of the Chief Justice of the Queensland Supreme Court was kind of based on whoever was closest then to the party in power, which was done during the time of Campbell, Newman Campbell. So let's start answering this, okay? Let's begin with the idea that when we speak of government, there are at least two kinds of government. We have the federal government and the state government, okay? I raised that point because, okay, this goes back a bit to the notion of separation of powers, okay? Bear with me. In a presidential form of government, there is full separation of powers. Let me repeat, in a presidential form of government, such as that in the United States, there is a full separation of powers in the sense that the executive, the judiciary, and the legislature are separate. The president and the members of the executive are not part of the legislature. That should be clear enough. In a parliamentary system of government, and especially in a Westminster form of government, such as what we have in the UK, in Australia, and in New Zealand, there's only a partial separation of powers because the Prime Minister and his cabinet also belong to Parliament. So in that case, there is a fusion, in a sense, of the executive and the legislature, which brings us later on to the discussion about ministerial responsibility and responsible government. Now, that is in relation to the federal government. In the federal government, there is a partial separation of powers. But in the states, let me repeat, in the states, there is really no separation of powers at all. Okay, let me slow down a bit on that. In the Commonwealth, in relation to the federal government, there is a partial separation of powers. So there's a fusion of the executive and the legislature. In that case, what is independent is really the judiciary. So in the Westminster form of government, and I'm talking now at the level of the Commonwealth, because of the partial separation of powers, the judiciary becomes the final bastion of independence. And in Australia, and in most Westminster jurisdictions, the judiciary is loath to any encroachment of its powers. There are two aspects to an encroachment into the judicial powers. One is the judiciary will not allow any other branch of government to wield judicial powers. That's one. Okay? The other aspect is the judiciary is also loath or will also not permit the imposition or the delegation of executive or legislative powers on the judiciary itself. So if Parliament, for example, passes a law where it clothes the judiciary with certain legislative powers or certain executive powers, such as the power to investigate, that kind of law will be struck down by the judiciary as being unconstitutional. Are we clear so far? Clear. Now, at the level of states, so I apologize for what's going on in the chat box. I simply can't read it. You could actually read. You could actually raise your points in the mic in a short while. Now, but at the level of states, there is no separation of powers at all, which means that on the one hand, we know that already the executive and the legislature are fused because the executive, the premier, or the head of the executive also, and his or her cabinet also form part of the legislature. The judiciary, however, it is actually permissible for the legislature, for example, to pass legislation that will clothe the judiciary with certain executive or even legislative powers. And there is nothing that the state judiciaries can do about that. Are we clear? So there is no separation of powers at the level of states, which means, therefore, it is possible for a state judge to actually be given the power to investigate certain crimes, or it might even be given the executive function of acting in behalf of the police, or perhaps becoming part of a parliamentary subcommittee. That is permissible at the level of states, in state governments, because in state governments, as we will later on see, there is no separation of powers. Was that clear enough? I just raised that because there was a point raised there somewhere. So when we speak of governments, therefore, let us be sure. Yeah, that's right. I think it can happen under sections unless a party is standing. Okay. So let's be sure that when we speak of governments in relation to separation of powers, we need to be clear whether we're speaking of the federation or the Commonwealth government or a state government. So going to this specific question now, what do you think of the implications of the idea of representative government or the power of judicial review? Anyone cares to take the floor? What are the implications?
Is it a provocative that the judiciary ensures that the legislative arm of government doesn't overstep its powers under the separation of powers? So I think in MV Tampa case, it showed that the legislative overstepped its mark by closing down government detention centres and turning the boats back. And then again, it talked a bit further. Another case was Barton and the Commonwealth showed that the legislative arm can only intervene in extreme cases of police power or police issues, emergency. Sorry. Am I on the right track?
Was that Patrick?
Yes.
Patrick, were you referring to the discussion question or were you referring to the points I earlier raised?
Both. No, sorry, just a discussion question.
Okay, yeah. So, sorry, the mic was quite strong. I couldn't quite hear what you were saying. So in answer to this discussion question, what was the answer there?
The answer was, the provocative judicial review ensures that representative government is maintained. In the Tampa case, legislative power oversteps its power within the separation of powers. The judiciary ensures the validity of the rule of law continues.
Okay, that's a possibility. I was going to go back to I'll go back to that point of the MV Tampa case just to be sure in a short while. The crucial point here in relation to the discussion question is that if you speak of representative government, the idea is that the executive and the members of the legislature actually represent the people. And they represent the people because they have been elected and voted into office. And the right of suffrage is in the Constitution. So it is clear that the Constitution says that the members of Parliament must be voted by the people. So in other words, we're quite clear that as far as the members of the Parliament are concerned, they represent the people. That's why we speak of a representative government. The members of the judiciary, however, are not elected by the people. They are appointed officials. And in that sense, therefore, because they're appointed, it's difficult for them to argue that they actually represent the people. And in fact, it might be a good thing. Because they are not appointed by the people, they are not beholden to the public. They don't really have to listen to the clamor of the public. Their decisions don't have to change according to what the views of the people might be at a specific point in time. But the crucial point that it also says is that because of the idea of the representative government, that in terms of judicial review, the judiciary will also avoid trying to, I'm looking for the correct word now, to second guess what the Parliament is saying. It will avoid trying to set the legislative agenda or the national agenda. It leaves it therefore to Parliament to determine, or even to the executive to determine, what the national agenda should be. So if, for example, Parliament says that there should be zero budget for education, no one can go to the courts to complain that, that is unconstitutional or that is legislation that contravenes any form of democracy. That is not possible. The judiciary will not step in when it comes to policies or national agenda. Are we clear so far? So it also means that that the judiciary will not, so assuming that the Prime Minister at some point decided, oh, we should get involved with the war in Syria. So we're going to bring along a battalion of army officers and soldiers to go to fight the war in Syria. No one can go to the judiciary and say, that decision of the Prime Minister is wrong, because actually the people don't like it. The judiciary also will not intervene. In that case, it will respect the decision of the executive as a representative of the people. Patrick, oh yeah, okay, that's fine. Patrick has muted his mic. Are we clear so far on that point? Now, going back to the MV Tampa case, the other key point in the MV Tampa case is that there is a distinction. So the executive power is actually stated in the Constitution. Okay, but the question is the power of the executive derived solely from the Constitution? So let me repeat that question. Where is that sound coming from? Patrick, can you turn off your mic? Thank you. When you want to say something, you just raise your hand and I'll give the mic to you. Now, the other point there is, as far as the power of the executive is concerned, because it is clearly stated in the Constitution, is the power of the executive solely derived from the Constitution? In other words, does the executive have power other than that which is in the Constitution? And the answer is no, because the executive retains what are known as residual or discretionary powers. Okay, so what this means is, when you ask, for example, I've heard that Tony Abbott is about to knight somebody, make somebody a knight, or Tony Abbott plans to go to war, or Tony Abbott is planning to ratify a treaty, or to enter into a treaty with this country, such as North Korea, just as an example. But it's not in the Constitution. That kind of power is not in the Constitution. Okay, let's begin by saying in the first place that the idea of the Prime Minister is not even in the Constitution. Okay, so the fact alone that the power of entering into treaties, the power to go to war, or even the power to enter into contracts, these are not in the Constitution, but they are part and parcel of the executive government for it to be fully functioning. Okay, so these are what are known as residual power. So, for example, the question of, does the Minister of Immigration and Border Protection have the power to turn back boats? Okay, and then you'd say, but there is no legislation which says that the Minister of Immigration and Border Protection has that power. And the answer is, it is within residual powers or discretionary powers of the executive. There is no need for specific legislation to empower the executive to do certain things. Okay, so there was also a case before, like, there was an attempt to extradite somebody who was then in Brazil. At that time, there was no extradition treaty between Australia and Brazil. So the question was, how can the Minister of Immigration attempt to extradite an Australian accused from Brazil to Australia in the absence of an extradition treaty? And the answer is, according to the High Court, the answer is that there are certain residual powers or discretionary powers that continue to be situated in the executive, even in the absence of specific legislation. That is also part and parcel of Arizona's ministerial prerogative, as Peter Mack would say in the chat box. Okay, so is that clear? So can we move on? Okay, hold on. Michelle, I'm feeling more confused now. Is the answer to the question the fact? Oh, okay. So, so in relation to this, okay, my problem is I often digress too much. I kind of chase too many things. So in relation to this specific discussion question, what it means is that because of the idea of representative government, when it comes to issues of national policy or issues of national agenda or issues of what national priorities should be, the judiciary will not entertain these types of questions. It will not, the judiciary will not impose its own views of what priorities or the legislative or what the national agenda should be. It will leave it to the parliament or the executive. In that case, the judiciary will say that that is a political question that is best left to the to parliament. So it may happen, for example, that there might be a question of gay marriage. A law might be passed allowing gay marriage, or a law may be passed saying that what are other controversial issues of it? Law about abortion, for example, and then somebody says, oh, that violates the rules of what democracy should be. Those types of questions are political questions which are best left to the legislature or the executive. And because these are political questions, on the basis of the idea of representative government, the judiciary will not intervene. Clear enough? Yep, so the judiciary is not, yep, so they will not get into political questions and issues. So moving on, clear enough, I hope. I don't know if that was relevant to the legal memorandum. It might have been. Oh, yeah, it was relevant to that question, discussion question 1, the discussion we had is relevant to actually to the legal memorandum assessment. One of the questions there touched on that topic. So moving on to question 2. To what extent do you think may the judiciary and institution, okay, so I already answered that. So we answer that, if it involves political decisions relating to tax rates, welfare benefits, and so on, the judiciary will not step in and get involved because they are political decisions. They are political questions. So they are non-justiciable, the judiciary will say. So are we clear? So that was just related to question 1. So we'll just move on to question 3. Okay, now, how many questions were there? Were there only 4 questions? Oh, there were 5. I'm just trying to find the time here. Okay, why is it said that it is by convention that a government that loses the support of parliament must resign? I'll give you a minute to try to answer this. We have enough time anyway. If necessary, we'll go beyond 7 o'clock. Now, if you go beyond 7, and there are some of you who might have to attend another class, feel free to drop out of our class here at any time if you need to. But we will extend beyond 7 o'clock for us to be able to go through all the questions that we've got here. So I'll give you a minute to answer that. Now, there was somebody who gave a good answer already. So it is by convention as it is not a written rule, said by Jerry. Jerry said, okay, good, very good. Yep, somebody said, Amanda, something pops up and it disappears. Amanda was saying it is tradition, not by constitutional decree. Good point. Now, how many students are actually here? We've got 45 participants, which is good. Okay, so it's so difficult to look at the chat box because the moment something comes in, it just pops, everything just goes up, and what I've been reading disappears. Okay, good. So there's been a lot of discussion, and it seems you know the answer here. Yep, very good. Okay. My name is pronounced as Man Joe, so that's Man Joe. My name is actually Manuel Jose. Actually, it's Manuel Jose. If you're a Filipino, but I say it's Man Joe. But that's actually my nickname. So it's Man Joe. So, oops, sorry, pressed the wrong one. So why is it that by convention, a government that loses the support of parliament must resign? There are actually 2 aspects of that question. What do we mean by convention? And why is it that the government must resign? Would anyone care to, I've seen a lot of very good answers here. Would anyone care to take the floor to answer that specific question?
I have an answer.
Yes, Josh. Yes, Josh, go ahead.
Because the executive cannot facilitate the functions of the country as a whole mostly because of it can't control the finances because Parliament controls finances. So basically, it doesn't have access to funds to run the country, basically. So.
Yes, so on the one hand, so very good. Thank you very much, George. That's correct. So on the one hand, if the government in power, meaning the Prime Minister and his cabinet and the coalition parties, are unable to pass supply legislation, or meaning the budget, the national budget for the following year, then government cannot function because all the money goes to the Commonwealth Consolidated Fund. So for that reason, it simply cannot govern because there is no budget. So it has to resign. Yep, so from Vivian, you can't run a car with a fuel. That's one. On the other aspect is, as Catherine pointed out, if the government loses support and confidence, not just about money this time. So how about the situation where a budget, it's not a question of supply, but there is a vote of no confidence against the Prime Minister? What then happens? Okay, so this time we have a situation where it's not about the budget because the budget has been passed, but there is a vote of no confidence against the Prime Minister. What then happens? Why must he resign? Why must he resign? What was the answer there?
He has to resign because the executive, the cabinet, makes the decisions to govern, and they're supposed to have the support of their members of the House. And if they don't have that support, then they effectively can't govern.
Good point. The question is, what if you have a situation where the Prime Minister does not have the support of Parliament, but he refuses to resign? What happens then?
Well, in this system, we would just elect a new, if it was their party, they would just elect a new Prime Minister. That's what they do. They go in and they have a vote and they have a challenger, and then they pick a new head of the party.
Yeah, so I agree with that. Doesn't that mean the Governor General has the power to dissolve the Parliament if there's no confidence anymore?
Okay. So very good. So, it's pretty obvious now that you're drawing on, the Whitlam sacking of Whitlam. You're now drawing on, the history of Australia. That's right. Who was it who met? Sorry, I couldn't get the name. So on the one hand, obviously it is within the power of Parliament to just elect a new Prime Minister. But on the other hand, it is within the power of the Governor General to step in. But what if you have a situation where, there is no, because, the problem typically is you need it's not just a question of plurality. You need an absolute majority to be able to elect a Prime Minister. Correct? So an absolute majority means assuming that it's 100%, it must be 50%. It must be 50% plus 1, meaning 51% of members of Parliament must be able to choose a Prime Minister. But what if that isn't possible? In other words, you can have two contending potential prime ministers, but none of them is able to have the vote of more than 50% of the members of Parliament. You know what I mean? Yep, Jamie, you can go. I'll see you next week. Okay, so what happens then?
So wouldn't the Governor General then dissolve the Parliament and then they'd have a general election? Yes,
that's the point. That's a possibility that the Governor General might actually come in and step in to dissolve the Parliament or even dismiss the Prime Minister and then talk with the various parties to determine who should be the next Prime Minister. Okay, but that can be quite tricky. So, there will be a lot of political flack, a lot of complaints if the Governor General does that, because in a sense, it is like the Governor General is intervening in the affairs of Parliament. So the Governor General will probably take a long, long time before deciding to step in to dismiss the Prime Minister. Okay, but that can happen, and it has happened before, but it typically shouldn't happen because that smacks of interference with the affairs of Parliament. Okay. Now, if we speak about convention, these are long-standing practices that, as a matter of principle, yeah, Audrey, you can go. Thank you. I'll see you soon. As a matter of practice, people just follow it because they're what makes the system of government work. Okay, so we're clear on that. Yeah. Okay, so we'll move on to question 4 now. Does the executive have quasi-law-making powers? How many are here still? We've still got 36. Okay. So for those who have a class after this, you're free to go. Thanks for joining us. What do we mean by that? Does the executive have quasi-judicial... Oh, sorry. Missed that. Sorry. Does the executive have quasi-law-making powers? What exactly does that mean? What does it mean?
Subordinate legislation under existing legislation.
Okay, who was that? Margie? Was it you, Margie? Can you explain that a bit further, Margie, please, if you could?
Not really, because I can't think of a situation.
Okay.
Sorry, that's as best as I can do.
Yeah, okay, so Peter has it for us. So in Victorian stevedoring, it's disappearing again. It was held that the legislature could delegate power to the executive. Yep, okay, so it is, in the case of Victorian stevedoring or the Dignan case, it is within the power of the legislature to pass what is known as subordinate, to enable or to empower the executive to pass subordinate legislation in the form of executive policies or directives that will thresh out the law that has been passed by Parliament. Okay, there is nothing unconstitutional about that. In the case of Dignan, meaning the Victorian stevedoring case, the High Court ruled that if the Parliament has the power to pass laws, it certainly has the power to pass a law that would empower the executive to craft subordinate legislation.
A better phrasing of the question would be, does the executive have legislative powers? And arguably they don't.
Yes.
That was because the legislature has already spoken and done its legislation. The executive has a certain discretion in anything it does. So strictly speaking, it wouldn't be a legislative power. It would just be execution of executive power.
That's a good point. Thank you, Martin. That's a very good point. So if the question were does the executive have lawmaking powers, the answer would be no, because lawmaking powers are vested in Parliament. Now, but there is a corollary question to that. Does it mean, therefore, that what if the executive wishes to craft some form of directives or executive policies that affect the lives of people, but there is no delegated authority coming from Parliament? Does it mean that the executive cannot craft executive directives or policies that directly affect the lives of people? It could be about it could be about issues of passports. It could be about issues of mowing of lawns or cutting of grass and those types of things. It could be issues about what business licenses could be given to certain persons. It could be issues of regulating, the plumbing industry and so on. So that's a question. Would the executive have to wait, or would the executive therefore have no power to enact, some kind of subordinate legislation in the absence of delegated authority from Parliament?
No, wouldn't the executive just put in place regulations and rules, laws, various things so that the country can run? And then if there was an issue, like if someone wanted to challenge that, then they would, and that's when it would come up, more or less.
Yeah. So those rules and regulations, Josh, would obviously be in the form of, in a sense, subordinate legislation as we would know it, right? So in the absence of a specific law passed by Parliament, would that be legal for the executive to do, to actually create rules and regulations that affect the people, even in the absence of delegated authority coming from Parliament? Would that be valid and legal?
Well, if they did that, would that then open them to judicial review?
It depends if there's an actual controversy going on. Judicial review only comes in if there is an actual controversy. In other words, there would be certain rights, there would be rights of people that are affected, or there is liability imposed on people.
That's what I mean. If they did something that eventuated that, then they would be open to judicial review.
Yes. So assuming that somebody has been affected by a rule or regulation passed by the executive, and there was no delegated authority coming from Parliament, would it mean that those rules and regulations created by the executive would be invalid or unconstitutional? Would it be a yes or a no? I want to see it in the chat box. Yes or no? Let me repeat the question. Assuming that the executive crafts or enacts rules and regulations affecting the people, and there is no delegated authority coming from Parliament, would those rules and regulations therefore be invalid? The answer is yes or no. Can I just see a yes or no coming from everyone here? Would they be invalid? Everyone is saying yes. Oh, okay. Say a no from Luis. Nope. Oh, well, no, it's only invalid. Nope. Okay. So majority of the students say it would be invalid. Actually, the answer is it would have been valid. I'm trying to look for I'm looking at how many students are here. Let me repeat that. Those rules and regulations would have been valid. Okay? They would have been valid because it's part of the residual powers of the executive. It's the only way by which the executive can function. It cannot always wait for the legislature to pass a law delegating certain authority to the executive to, for it to function in certain ways. That is valid. Okay? However, it would be invalid if there is an existing law passed by Parliament. Okay? So if there is already a law passed by Parliament, the executive cannot enact or create rules or regulations that would contravene the laws passed by Parliament. That would be invalid. But otherwise, if the space is open, in other words, the field of law is open. It's part of discretionary power. So if the field of law is open because Parliament has not legislated on that subject, it is certainly within the power of the executive to craft or create rules and regulations. And those rules and regulations that affect the people in the form of giving them rights or imposing liabilities on them would be legal. They would be valid. So the only time it would be impermissible is when there is an existing law passed by Parliament. The executive cannot enact rules or regulations that would contravene the laws passed by Parliament. Are we clear? On the other hand, assuming that the executive has passed certain rules and regulations, and then Parliament passes a law that abrogates or modifies or changes what is in the rules and regulations, that law passed by Parliament would override the rules and regulations created by Parliament. And the reason is, the lawmaking powers are in Parliament. So it is within the power of Parliament. Therefore, to change those rules and regulations passed by the executive. Now, if you want to be able to push this a bit further, there are, however, constraints on the laws that Parliament can pass. So in other words, if there are certain powers that are clearly within the power of the executive, such as the power to determine the power to determine to enter into diplomatic relations, or let's say the power to go to war. Okay, the question is, if the Prime Minister, for example, determines that Australia must go to war or that it must draft soldiers, would it be within the power of Parliament to actually pass legislation to change the exercise with the executive of its executive powers? The answer is the answers are most likely not, because if the exercise by the executive of its powers is clearly within the realm of the executive power, it will not be permissible for the legislature to intervene. in the powers of the executive. Clear enough? Okay. So we go to the final question now. And this is a crucial point as well, because actually questions 4 and question 5 touch on the legal memorandum assessment. So we're just talking of broad principles here, because the moment you understand the broad principles of constitutional law, it's actually quite easy to answer case problems, even in the absence of even if you don't really know what the case law might be. It's very crucial for us to understand what the basic constitutional law principles are. Okay, so most of the questions here actually are tied up with the legal memorandum assessment that we have. So that's good. How many students do we have so far? Can't see again. Sorry. Oops. Yep. Okay, 34 students. So, does the executive have quasi-judicial powers? Oh, okay. I want a yes or no. Can people just say yes or no? Yes, 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 yes. No, yes, no. Okay, good. Okay. So, what do we mean by does the executive have quasi-judicial powers? Before we even say yes or no. Any specific examples? Why do we say it's quasi?
Because it's apparent, kind of like seemingly,
Yep.
it's not like express, but it's like implied almost. I don't know. It's just like the definition of that makes sense in my head.
Okay. Close, close. There was a phrase you used, Josh, that was correct. You were close, but not, there was something, that was okay, but we missed something there. When we say quasi, what does it mean? Quasi. We actually mean it's almost like. Okay, so it's almost like, yes, semi. So it's like, okay, it's like, so does the executive have judicial-like powers? So that's almost, so it's not actually judicial powers, because obviously judicial powers are lie with the judiciary. Does the executive have judicial-like powers, powers like that of a judge? And the answer is yes. Yep. So we're speaking of administrative tribunals. So ASIC, APRA, so on. Okay, good. Now, what's the point there? Is that valid? Is that constitutional? When we say that, I mean, what's the basis to say that the executive actually has quasi-judicial powers?
If the executive acts outside their powers in exercising the judicial powers or quasi-judicial powers, then it's still administratively reviewable by judicial review.
Okay, but why would it be valid? I mean, how can it be valid for the executive to kind of exercise judge-like powers, quasi-judicial powers? How can that be possible?
Because Parliament's given them that power. The legislature has given the executive the power to have the administrative tribunals based on the merits.
Okay, let's focus on that first. So let's focus on this specific situation where Parliament has passed a law enabling the executive to have administrative tribunals. Because the other question would have been, what if there is no law? Can the executive actually, exercise quasi-judicial powers? We'll go back to that in a short while. But going back to that specific example, what if you have a situation where Parliament actually passes a law where administrative tribunals are created? Isn't that a violation of, the powers of the judiciary? Doesn't that infringe upon the powers of the judiciary? And as we said, the judiciary has always been loath to any small infringement of the judicial powers because it is the last bastion, in a sense, of democracy. Because of the fusion of the executive and the legislature. How can the judiciary tolerate that?
Only 20 minutes ago, we were talking about, how can, if I've completely forgotten what I was saying, we were saying, how can the executive have power if Parliament didn't give it to it? Or how can the executive exercise power when they're not directly allowed by the people? I think if the Parliament being ultimately responsible to the people, they have ultimate power to give whatever powers they like to the executive, and those powers are challengeable by judicial review.
Okay, Martin, that's a very strong point. So I raised this specific question to you. Would it be permissible, just to be specific, more specific now, following your logic, would it actually be permissible for Parliament to pass legislation saying that the executive can actually exercise judicial powers? Not quasi-judicial this time, judicial powers.
No, because that would be unconstitutional in terms of the Constitution. But if they passed a law that gave them power that was within the context of what the Constitution allowed, then perhaps, but they would still be limited power.
Okay. So, I mean, so we're quite clear. We're in agreement, and I agree with you. Parliament cannot pass a law that would clothe the executive with judicial powers. In the same manner that Parliament cannot pass a law that would give itself judicial powers. That's not permissible.
It's not.
No.
But I think in my earlier answer, I talked about executive having a certain discretion in making decisions. Perhaps those judicial powers are within that discretion. If they were wide-ranging judicial powers, then no, that would clearly infringe on the separation of powers. Okay.
So, thank you, Martin. That's good. The crucial point here is that as a basic point, when we speak of quasi-judicial powers, they quasi, meaning they're not actually judicial powers, they're almost like judicial powers. When we speak of judicial powers, there usually is an actual controversy involving parties that affect rights and obligations or imposes liabilities on actual parties. So if there is an actual controversy that affects rights and obligations or imposes a liability on actual parties, that would involve the exercise of judicial powers. That would involve the exercise of judicial review. Okay? When we speak of quasi-judicial powers, what it essentially means is that it is possible that there is no exercise of actual judicial powers because there is no actual controversy. So in other words, it may just be a single person, like a father might complain that he has not been getting child support, so he goes to child support agency. He can do it on his own. That does not involve the exercise of judicial power. Or it may be a person wants to be registered as a teacher, and the board says no. That again is an example of there is no actual controversy between persons here. It's actually just one person being affected. Okay, so it boils down therefore to the issue of whether or not there is an actual controversy involving individuals, persons, or corporations that affect their rights and obligations or imposes a liability. So you go back to the question of how do we define an actual controversy? Okay. So it's 7:20. Any questions before we end this? And I think we've covered all those questions so far. Any questions before we end tonight's session? And I'm very glad that, 31 people are still here. Question? We're good. We're good. Okay. So thank you so much. Yes.
Banjo,
yes.
Peter Mac. I'm a bit worried about there being no separation of powers in the states. I know that Queensland's got a unicameral government, but don't judges have tenure? Isn't that a form of separation of powers?
Would they have tenure? No. Tenure only applies to the federal judges.
I thought all the Chapter 3 courts, the Supreme Court of Queensland, they have. Can't.
That's exactly my point there. If they are Chapter 3 courts, then there would be tenure because it is in the Constitution. Otherwise, if the basis of the existence of a court is actually a law passed by Parliament, by the state Parliament, so let me repeat, if the basis of the existence of a specific court in the state is a law passed by the state Parliament, then it is within the power of that same Parliament to change the law. But in relation to a Chapter 3 court, meaning it's a federal court, what it means is that judges in Chapter 3 courts obviously have tenure according to the Constitution.
Okay, so but the Supreme Court of Queensland, you're saying that's a federal court, not a state court.
Let me clarify that. Generally, state courts are created by the state. They are institutions of the state. They are state courts. They are not federal courts. However, the High Court in one case has said that it is not within the power of states to actually remove the power of appeals from states to the federal courts. So where a parliament, a state parliament, attempts to interfere with the functions of a state judiciary to such an extent that it actually infringes on the independence of the judiciary as it affects the level of the federal courts, then the Chapter 3 courts will not allow that. Because there still has got to be an opportunity for people in states to actually elevate matters to the High Court or to the federal courts.
So the magistrates court and the district court, is it a creature of state legislature, is it?
Yes, it is. Yes, it is. So the parliament can do what it wishes to do with it. They can even abolish them.
So the hierarchy, though, still goes from magistrates to the district court, and then the right of appeal lies with the Supreme Court as the highest court in the state.
In relation to the hierarchy of state courts, it depends on the state legislation.
Okay.
It depends. I wouldn't know. Meaning it could be different in Queensland, could be different in New South Wales. It depends on state legislation.
Because I thought the states existed before the federation, therefore
Yes.
they were the highest court of each state and weren't ousted just by the federation.
That's correct. But upon federation, because of the existence of the Commonwealth Constitution, in terms of hierarchy, the highest court is now, based on the Constitution, it is now the High Court of Australia.
That's right. So the original states' constitutions that you're saying they could have been amended post-federation?
Upon federation, the state constitutions remain subsisting, except to the extent that the state constitutions contravened what was in the Commonwealth Constitution.
Okay. Okay.
So
that's what I'm saying. I still think there is a separation of powers in the states, in the state governments, because the Supreme Court is the highest court in the state, and it would have been a constitutional court of the state pre-federation. So there is a separation of powers, despite there being unicameral government in Queensland. The judiciary is still able to overturn laws if they're unconstitutional.
No. Hold on. Okay, in theory, in states, we're talking of states here. In theory, there is separation of powers in the sense that you can identify the executive from the legislature and from the executive and from the judiciary. In actual practice, there is no separation of powers at the level of states. And when we say this, it actually means that it is permissible, for example, of parliament to clothe the members of the judiciary with executive functions. And
that's due to the state constitution, or just due to their own?
That's exactly what I meant, depending on the state constitution. Remember, the state constitution is just an ordinary law. It can be changed by the state parliament at any time.
don't they need a special kind of vote, though, to do something like that?
Again, it depends on what the state constitution provides. But the state constitution is just another ordinary law. Okay, so what it means is, the reason why I said there is no separation of powers at the level of the state is that it is permissible for Parliament to pass legislation clothing members of the judiciary with executive functions. That
Can you give me an example of that? Is that happened lately?
An example might be that the magistrate court is permitted to investigate allegations of drug abuse. The magistrate, for example, the magistrate judge can be clothed with the power to investigate if people might be members of bikie gangs.
Okay.
That would be valid. That would be legal at the level of the state, because there is no separation of powers. If this had been at the level of federal courts, where federal judges, let's say members of the Federal Circuit Court, are given certain police powers in the sense that they can issue warrants of arrest on their own in the absence of an actual controversy, that would be unconstitutional.
Okay, I get what you're saying. Yes. Okay.
Yeah. Clear enough? So at the level of the federal government, there is partial separation of powers. The judiciary cannot be clothed with either executive or legislative powers. That would be unconstitutional. But at the level of the state, the judiciary can be given legislative and even executive functions, and that would be legal and constitutional. Okay, so others are complaining about dinner. It's almost 7:30. Anything else before we go? None. So thanks so much, everyone, and I hope to see you next week. Start working on your legal memorandum. Good night, everyone. Thanks.
Okay.
Bye.